Hello everyone, welcome to Management 413 Employment Law here at the UAB Collat School of Business. In this video we will be covering accommodation of individuals with disability or individuals on the basis of their religion using Chapter 10 of our textbook, Employment Law for Human Resource Practice. Here's an outline of what we will be covering. There are only two protected classes that we have talked about that require some sort of accommodation under the law, and they are the protected class of disability and the protected class of religion. However, the exact requirements for accommodation are very different for each of those. The employer's obligation to accommodate is significantly more extensive for disability than it is for religion. There are two laws that would potentially govern in a request for an accommodation based on a disability. For all employers, the Americans with Disabilities Act would control, and for public employers, say for example a public university like UAB, the Federal Rehabilitation Act from the early 1970s would also apply. Here are the elements of a claim that somebody might make if he or she had not been accommodated. First, he or she has to have a disability. We'll be talking about how that is defined. Second, he or she has to be qualified. We'll be talking about some possible exceptions there. Third, the employee's need for an accommodation has to be made known or should have been known by the employer. You can't keep it a secret and expect the employer to do something. And then finally, there has to be an accommodation out there that is reasonable. First, what is a disability under the Americans with Disabilities Act? The courts use a three-prong test. In other words, there are three different ways that you can be disabled under the ADA. We'll be talking about all of those. About 10 years ago, the Congress observed what had happened under the first 15 years or so of experience with the ADA and concluded that the courts had been too hard on people with disabilities, and there were a number of amendments made that will require interpretation of it to be more positive for people claiming disabilities. For example, too many courts, Congress believed, felt that someone was no longer disabled and therefore not requiring the protections of the law if they had found a correction for the disability. So let's look at what it means to be disabled. The first, we could say the largest group of people would be someone with an actual disability. Both physical and mental impairments are included here. The law does not itself have a list of disabilities, but the Equal Employment Opportunity Commission has identified some that should be considered a disability. The focus of the law is not on the job label, but on the actual functioning, the actual functions that are required in the job. There are a few conditions that are expressly included. You can see here another one that is expressly excluded as a disability that would entitle you to protection would be kleptomania. The test for determining whether someone is actually disabled is whether the disability substantially limits one or more of major life activities. Those are some key words. It has to substantially limit a major life activity. And here are some major life activities. Please stop and pause and make sure you understand these. These will be at the heart of the jobs of many of you who will become HR professionals. Caring for yourself, performing a manual task, seeing, hearing, eating, speaking. Look at this next one. Concentrating, bending, breathing, standing. What about drug users? We talked about this in an earlier class. Illegal drug users are not disabled, but if you have undergone treatment and are no longer currently using illegal drugs, you are protected by the ADA. You are considered disabled. The second prong of determining who is and is not disabled would be if you have a record of being disabled. Even if your disability was in the past, if you can show that you were discriminated against on the basis of a past disability, you might be entitled to protection under the ADA. The third prong of determining disability would be those who are mistakenly regarded as being disabled, even if they are not. The next item that requires some interpretation and study for a claim of disability by, say, an applicant or someone seeking a promotion is whether the individual is qualified. That is a very important point. The ADA does not require that people who are unqualified be put into jobs. They must be qualified. That means they have to have the necessary skills, education, and experience. Now, there is an exception for those who pose a direct threat to the health and safety of others that we'll be talking about in a minute. Even if you are qualified, if you are a direct threat, then you probably do not get the protections of the ADA. Most jobs consist of both essential functions as well as non-essential functions. Look at this example. A word processing clerical job might also include not only the actual act of word processing, but also perhaps carrying boxes of copy paper into the copy room. That copy paper box carrying is probably not an essential function, and you could probably not exclude someone from a job if they were unable to lift heavy boxes. We will have a simulation on this topic. A candy factory worker in Chapter 10, Question 2, asked for an exemption from a difficult task in her job on the candy manufacturing line after she came back from back surgery, and a pair of you will be assigned to tell us how that should come out. How does the employer go about determining what are the essential functions of a particular job? Here are some guidelines for how to do that. The process should be well documented. We recognize that the employer's judgment will come into play here, but the job description should almost certainly include the essential job functions. The focus should be on what needs to be accomplished, not on how it should be accomplished. Here's an example case in your book. Please make sure you understand this of what was and was not a essential job function. You can see here that a truck driver who lost a leg in a motorcycle accident was considered qualified, even though he was disabled, despite the fact that his employer said, well, we like our truck drivers also to be able to operate an excavator. That was considered not an essential job function. Again, disabled persons must be qualified. They must meet the same requirements for education, skill, and experience. But you always need to be careful in your employment tests, as we talked about in an earlier learning module, that if you are going to, in your employment tests and your other screening, perhaps screen out a person with a disability, you might be found to be discriminating on the basis of a disability. An example here would be a driver's license. We'll talk about that in one of our simulations. Direct threat. A person is qualified, but if they impose a direct threat, they can be excluded from protection of the ADA. An example of this might be a food handler who otherwise could handle the job of being a food handler, say in a cafeteria, but had infectious hepatitis. Look at an unsuccessful attempt by an employer to exclude someone from protection of the ADA in EEOC versus DuPont, a lab clerk who had severe scoliosis. Moving on, if someone is qualified and is disabled, the Focus then shifts to the employer providing a reasonable accommodation. Here are some examples of reasonable accommodations. A ramp, for example, for a wheelchair employee. We will have a simulation on this. The call center representative with brittle bone disease whose employer would not give her a parking space or her own cubicle. Here's another example in Chapter 10, Question 7 of a medical resident with Asperger's disorder. A peer review will be assigned to that and help us reason through what the result should be. I will provide the actual result, and that might be on the in your question pool for the second exam. Accommodating an employee should be an ongoing interactive process that focuses on the essential job functions. It shouldn't be a one-shot deal that is all or nothing at the beginning. People's conditions change. There ought to be a dialogue going back and forth. The employer has to act in good faith. Here are some words to guide what is and is not a reasonable accommodation. Remember that only reasonable accommodations have to be offered. Sometimes employees are surprised to see that the courts take a very balanced view of what is reasonable. You do not have to give an employee his or her preferred options. Just because you gave it to somebody else in a similar situation does not mean you have to give it again. You do not have to create a new position for someone. You do not have to redo a job description to eliminate essential functions from it in order to accommodate someone. Take a look at the process that Oakland County, California went through when they were trying to accommodate a deaf lifeguard in Keith versus County of Oakland. The standard for accommodation by an employer says that if it would impose an undue hardship on a business, the business does not have to provide the accommodation. It doesn't have to be a business. It could really be any employer. Whether or not there is an undue hardship depends upon the particular financial circumstances of the organization. In any event, if an employer is going to argue undue hardship, they should be documenting the cost and exactly what the operational problems are. It should be remembering that there are often grants from the government and even tax breaks that would help pay for the cost. Moving on to accommodation of religion. Religion, of course, is a protected class under Title VII of the Civil Rights Act of 1964. A process for accommodating religion is required, but the requirement for exactly what the accommodation has to be is very different. It's a very lesser standard for employers. Sometimes there can be disputes over exactly what is a religion. Here, the government, the courts, take a broad approach to what is a religion. They do not require that it be a specific recognized religion. It focuses on what a person not only is, considers himself or herself, but also how a person expresses his or her religion. It's the behavior that the courts will look at. You can successfully argue that your collection of moral and ethical beliefs is a religion. You don't have to believe in a particular God or in a deity of all. It doesn't have to be a popular religion. It merely must be sincerely held. However, veganism is not a religion. Look at the case on page 359 of your textbook. Here are the elements of a claim for accommodating a religion. Stop and pause and make sure that you understand those. When it comes to what an employer has to do, as I said, the obligation on an employer is considerably less. The Supreme Court has said that employers really are only required to make de minimis, that is, very small changes in their operations, and they would consider swaps, facilitating swaps between employees, using up personal time, providing floating holidays to be de minimis accommodations. Here's an example, however, of a court saying that the accommodation for someone with a request based on religion was not enough. Please stop and pause and make sure you understand that. Religion can present some other difficult situations for an employer. What do you do if you have an employee who is trying to proselytize, that is, recruit other employees for his or her religion? On the one hand, that it might be considered an accommodation for the person who's doing the proselytizing, because that might be a sincerely held belief of their religion. On the other hand, the other employees might consider this to be harassment. Public employers have to be very careful not to limit religious speech, perhaps more careful than private employers, because the First Amendment applies to public employers, and the First Amendment protects the free exercise of religion. Take a look at the textbook case on page 373, where a California agency was told that it could not stop a computer analyst from incorporating the phrase servant of the Lord Jesus Christ into all of his work. Special exceptions have to be made for religious organizations who have to make decisions about their employees. If they make a decision that someone is not fulfilling the requirements of a religion, it would not make sense for Title VII then to be used by the person who had been taken action against to say, well, I was discriminated against on the basis of my religion. Religious organizations can limit employment or give a preference to people who share the same faith. So, for example, if you are a religious organization and fire somebody for boring your congregants, that would probably not give rise to a Title VII claim for discrimination based on religion if the pastor were to sue. We have a simulation on this very topic. Look at Chapter 10, Question 10, and the answer to this will potentially be in the pool of questions. That's it for this set of slides. In our next learning module, we will be looking at the very important topic of how an employer should handle conflicts that arise in the lives of their workers, between their work lives and their personal lives.